Hey everyone, Harry here to talk about Judge Scott McAfee's decision to toss three more counts from the Fulton County indictment. First things first, how did this happen? Since the case, as we know, is on appeal on Trump's motion to recuse Fani Willis, it's because two of the defendants, John Eastman and another, didn't join that appeal. So they are still before Judge McAfee. So his ruling only applies to them technically, but as soon as the rest of the defendants return to his court after the recusal motion is decided, that decision that he just made to dismiss the counts will apply to them. So he has effectively ruled that three counts against Trump and all the others have been who are named in those counts have been dismissed, but technically not Trump yet. Okay, point two to emphasize, the headline here is he dismisses three counts, but actually it's the bottom line of yesterday is it's a bad day for the defendants for a couple reasons. First, the motion that they made, that he decided those few counts based on, they threw at the wall all kinds of theories about the supremacy clause and why counts had to be dismissed. And he rejected most all of them in a very meticulous, one foot in front of the other, methodical opinion. He continues to impress, I would say, in his overall thoughtfulness and absence of apparent bias. But he did let in these three. But even more importantly, and this is not in the headlines yesterday because it was a separate ruling, some of the stories mentioned in passing, he approved in a separate ruling for form and constitutional substance the whole case really, which is the RICO count that sweeps everything else in. And there's been a lot of discussion. Was it a smart move by Fani Willis or not? It really makes the case very, very sprawling. There's a lot to be said about it. Of course, right now, the case is in deep freeze coma, and that issue won't come up again unless it is back. But still, the case is basically a RICO case with 40 other counts kind of thrown in. So that core case that drives all the evidence, that would drive the sentence, that gets in almost everything as an act in furtherance of, that has been now affirmed as being on solid ground. That's by far the more important development of yesterday. Okay, so what about these three counts? It's actually pretty interesting, and he bases it all on a Supreme Court 19th century case, I think 1890, that says a state court, a state jurisdiction can't punish someone for committing perjury in a federal proceeding. So you go into district court and you lie under oath, federal district court. The Supreme Court case says, look, it's the federal government that sets the obligation to tell the truth under penalty of perjury, under penalty of a criminal conviction, because people generally are not prohibited by the criminal law from lying. So it's the federal government that sets it. So under the supremacy clause, this is a Supreme Court case, it's only the feds who can punish. You can't have the states trying to come in and take advantage of that lie that the federal government has said people can't do and charge it in state court. And this is a little bit odd to us now, but it's all part of the early constitutional history. We are at the end of the 19th century, but people being generally afraid that states would overreach to try to punish people based here on federal law, or people who have committed perjury in federal court, and that should be the lookout of the feds. The concern driving the decision is you don't want states to be able to just forage around and find people who have committed perjury in federal court if for some reason the feds decide they don't want to do the case. So that's the principle. Now, McAfee's application of that principle is a little broad, but I think completely defensible if you look at the 1890 case. Not to say it could never be reversed, although, in general, as one goes up the ladder here, it gets better for Trump. So you wouldn't see as part of the overall pattern for courts of appeals striking down district courts who do things that are good for Trump. But the basic idea here is the false certificates that were filed, and they're really sort of three different counts. There's filing false documents. There's the electoral certificates themselves being fraudulent. There's the attempt to do so. All of those are false and fraudulent as based on a command of federal law, just like when you raise your right hand and lie in federal district court, you commit perjury by virtue of federal law. So McAfee has held, I think, tenably. You can see the argument on the other side, but nothing wild-eyed about it, nothing, overreaching, nothing trying to put his thumb on the scale for Trump. He's held that principle applies here to state charges about filing false documents when those documents, the requirement to be truthful in them, is created by federal law. So that's the notion that he uses to dismiss three of the counts. And not every defendant was charged with three, but the main ones we know, and Trump included, were charged with those three. So we can expect when it comes back down that those three will go away as to Trump. And more generally, you can imagine maybe Felony Willis's office fighting about that down the line, but I think it's going to stand up. And, they've got so much more to worry about, including, in a good way, if it ever comes back to them, the trial and proof of the RICO count that has been affirmed, that I think this will probably stick, and I don't think it will affect penalty too much, etc. So again, if we're thinking about McAfee and worried about a Eileen Cannon kind of pattern, it's not. He is in court and out of court in his writing. Pretty methodical and judicial, I would say. So bottom line here is dismissal of three counts on a not, unassailable, but pretty good, I'd say, argument based on this 1890 case. But overall, bad day for defendants. A lot of supremacy clause theories fail. And most importantly, the core charge, the RICO charge at the heart of everything that gets everything in, has been upheld. And, if and when this case comes back, that's the thing that's going to matter. That's the thing that's going to drive all the proof, all the penalties, everything. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.